Just to add on to the record for clarification, during the break, the specific admissions that I went through, we found the pages and the line numbers on the typewritten copy, and I'd just like to put those on the record unless you'd like me to wait till rebuttal.
We'll do it in your rebuttal.
Thank you.
Okay, Glancy, are you ready with your argument?
Yes, Your Honor, thank you. Your Honor, we're here today because the people are appealing the district court's decision to deny the bindover of Sean Phillips on the charge of open murder. Specifically, the court found that the prosecution failed to show that any activity of Sean Phillips was indeed a criminal act that caused the death of baby Kate. There were no facts presented by the prosecution to support any manner of death of Catherine, whether by accident or by criminal act, and that there was simply no proof of any criminal agency causing the death of Catherine Phillips. The people argued today that the judge failed to acknowledge the new evidence, that being the testimony of Deputy Baum, the testimony of Mr. Ruba, of Mr. Burton, and the letter that Sean wrote from prison. I believe that in reviewing the transcript, it shows that the judge did examine the testimony of those individuals, even questioned some of those witnesses from the bench to answer some of the questions the court had. And I believe that he considered the weight and the credibility of that testimony. I will get into that a little bit later on. In looking at the testimony of all of the witnesses, the people argue that the history of Ariel and Sean's relationship is not admissible. However, I believe that in looking at all of the case law that they cited, most of the cases refer to a history between the parties of violence or other activities. And I think that the testimony of Ms. Cortland shows that Sean and her had a loving relationship, and that the relationship was improving during Ariel's pregnancy with Catherine, and that their relationship improved after Catherine's birth. That after Catherine's birth, Sean was bonded to the child. He would go over there after work and spend the weekends with Ariel and the baby. When Ariel was at work, he would go over there and babysit the child, took care of, would provide diapers and things along those lines to Ariel to help support the child. And there was even testimony that on one occasion that Catherine had an explosive diaper so much that it was all over the house, and when Ariel came home, Sean had bathed baby Kate and had cleaned up the apartment and was doing everything that would be expected of a father. I think all of that is relevant to show how he treated Catherine, whether or not they, as the people are arguing, he had motive, and I believe that motive they're trying to manufacture, twisting some of the facts of this case. They had a history of arguing over custody of their other daughter, Haley. There was testimony that the police were called on numerous occasions. However, no one was ever arrested, and those never involved any threats of violence or actual violence. There was testimony from numerous people. Ariel herself, Kim Phillips, Sean's mother, and even Dan Rupa, that when the parties would argue, there was never any threats of violence, that Sean never raised his voice, he remained quite calm, and that during any arguments, it was generally Ariel that was the one that would get excited. In addressing the issues of Sean's motive that he was pushing Ariel to have an abortion or an adoption, there was testimony that at one point that Ariel couldn't remember who brought up those topics first. And that is in regards to the abortion, that Ariel had texted Sean and called him on numerous occasions, even asking for money for the abortion, and she was actively seeking out and researching that issue, although she states that she had never really considered that possibility. Then we move on to the issue of adoption. Both for abortion and adoption, Ariel testified that Sean's reasonings for having an abortion or adoption were very reasonable and logical. It was that they weren't sure if they could afford another child. She was working part-time. He was in the Army, and as I believe the reserve, and he was concerned that based on his limited pay that they may not be able to afford a child, or that if he were to be put into active duty, that if he were to be injured or lose his life, that she would be left alone raising 2 children, and that would be quite difficult. And they had quite a bit of experience that, both being very young parents and going through the difficulties of raising their older child. I believe that there was testimony that even during these discussions of adoption or abortion, Sean never made any threat that if Ariel did not go through with either an abortion or an adoption, that he would cause any harm to her or to the unborn child or the child once the child was born. And I think that they then argue that the court failed to acknowledge the testimony of Deputy Baum. That was that when he was served almost 3.5 years prior to these murder charges being brought, that he stated that he wasn't going to pay for a child. I don't believe that there was, in the prior case, there was ever any testimony of this. There was never any reports of this in any police reports. And this was new testimony that did come out, and I think that the judge did weigh the credibility and the timing of that testimony. In regards to Mr. Ruba and the statement that Sean could hide a body, the court looked at that testimony and even questioned Mr. Ruba himself regarding the timing of this statement. Mr. Ruba stated that he couldn't remember all of the facts and circumstances related to when this statement was made, but he did mention that this would have been a time when Sean and Mr. Ruba and maybe other individuals were out in the garage drinking or smoking marijuana. Mr. Ruba had previously testified that he wasn't smoking marijuana. In this preliminary exam, he admitted that he was. He also, they state that Sean made those statements in reference to his military training. However, the actual testimony was that Mr. Ruba couldn't remember in what reference those statements were made. He only believed that it may have been related to his military training, but that was not what they were, he couldn't say that's what they were talking about at the time. And Sean never said, because of my military training, I can do X, Y, and Z. Mr. Ruba did note that in making those statements, so that Ariel and or baby Catherine were not the subject of that conversation. The only thing that Mr. Ruba was actually clear about was that he had witnessed Sean and Ariel argue about custody of Haley on numerous times, And he noted that Sean never yelled, raised his voice, got out of control, and that he had never heard Sean threaten any physical violence or never witnessed any physical violence or harm towards Ariel or any of the children. In looking at the testimony of Mr. Burton, I believe that the court also looked at the timing of his testimony and that some of the facts of Mr. Burton's testimony were not did not quite fit the facts of the case. They were supposedly talking about Kobe Bryant and Tiger Woods' wives and other women getting their money. And Mr. Burton testified that Sean said that he had a similar situation, indicating that Sean stated that he had a girl who had a baby that was not his and that the woman wasn't getting a dime from him. However, for all of these times that they specifically talked, Mr. Burton didn't know anything about Mr. Phillips' situation. He wasn't aware that Sean was never ordered to pay any child support in regards to their other daughter, Haley, that in fact Ariel at one time was paying child support to Sean, that Mr. Burton didn't even know that Sean had other children, nor did he know the names of the children. And I believe that Mr. Burton's statements all came out after the letter of Mr. Phillips was released. And so I don't think that there's anything in Mr. Burton's statement that adds any credibility. There was nothing new that hadn't been already discovered. There was no statements of where Sean left the body or how it happened. They were very broad statements that don't quite correlate to the issues of Tiger Woods' wives trying to get their money. Then looking at the letter, although it's not specifically stated in the opening of the judge's opinion, clearly he examined the letter as well. And I think that the testimony from the witnesses support the letter. Ariel, when this incident occurred, they were back at the apartment and she unbuckled the baby from the car seat, telling Sean that she was going to go get the stroller to go to the hospital. She then placed the baby back in the car, unbeknownst to Sean, and closed the door and walked towards the apartment. He left in his car and he went to Wendy's. That's stated in the letter. It's stated that and there was testimony that a receipt was found at Sean's parents' house showing that he had in fact gone to Wendy's almost directly after leaving the apartment. His whereabouts were unknown for 2 hours because his phone was shut off. However, there was testimony that this was quite typical during their arguments. Ariel testified that Sean would typically shut his phone off because she would call him repeatedly when they were having a disagreement, and instead of continually putting the phone through to voicemail, he would shut the phone off. The statement from the letter shows nothing and doesn't support anything other than this was anything but an accident. It doesn't support that this was done by a criminal act. I don't believe any of the testimony from any of the witnesses that was clearly considered by the district court in this matter shows that this was done by a criminal act. And I believe that absent some showing of a criminal agency, there's a number of explanations for a disappearance, including an accident. In looking at the decision of the district court, I believe that it was a well thought out and reasoned opinion. The judge in this matter took into consideration all of the testimony, weighed the evidence and credibility of the witnesses, and came to a decision based on the facts and the law. And I don't believe that there was an abuse of discretion by the district court in this matter. I believe that this court, in looking at the cases that were cited by the people, and in comparing those to the facts in this case, we have People versus Wadel, which there was a history of violence between the parties. They were going through, let me pull up that case here for just a second. In that case, there was no body was found, and based on the testimony, there were frequent and loud arguments and a pattern of violence between the victim and the defendant. The people established that the defendant had a motive to murder the victim because at the time of the disappearance, the couple was going through a divorce and their relationship had devolved into violence. In this case, there is no testimony of any violence on behalf of Mr. Phillips. Same thing in People versus Brassic. There was, again, a history of violence. The individual had been missing for a long period of time and was last seen with the defendant. There was a history of the defendant being violent, and it was likely that a criminal act was performed that led to the victim's disappearance, and that was a finding by the court there. In People versus Fisher, in this case, there was no evidence of any bloodstains or a murder weapon linking the victim to, or the defendant to the victim's death. And in that case, there was even reported violence, and the defendant had threatened to kill the victim 3 months prior. And in that case, the court failed to find that the corpus delicti had been proven. In People versus Stewart, which they mentioned, that case, there was a plan to kill the victim, and that was shared with a third party, who then that person also requested that that third party be an alibi, and then called the individual up and said the crime has been completed and asked him to go along with the alibi that he had come up with. There's other cases that have been cited in the brief, and I'm sure the court is aware of it. The one case that the people have relied on and argued to the court is the Supreme Court case of People versus Nelson. What they failed to mention is what happened in that case in arguing the holding of the Supreme Court, and that was that the person was convicted because they had a possible motive and opportunity to kill the victim, and that motive was that they were racist and were quite vocal about that, and they had made inconsistent statements. This case has been remanded to all the way back down to the trial court for a new trial based on new evidence that actually somebody else had committed the crime. And I think that that is a prime example of pursuing a murder case where there's nothing but circumstantial evidence to support a possible position that there was a criminal act that led to the disappearance. And I think that's what we have here, is nothing but the most circumstantial evidence to support that something did happen, and there's no evidence to support what happened was a criminal act. Based on all of these factors, I believe that the court did come to the proper decision, that the decision was based on the facts of the case, and that the court came to the correct decision. And case law is that even if the circuit court in this matter, hearing the appeal, doesn't agree with the decision of the district court, that this court should not substitute its judgment for that of the district court unless there's a clear abuse of discretion, which I don't believe has occurred here, and I believe that people have failed to show that there was an abuse of discretion. Therefore, I would be requesting that the circuit court uphold the decision of the district court in this matter, denying the bindover and dismissing the charges of open murder against Mr. Phillips.
As far as the reliance on abuse of discretion cases, did you have any response to the prosecutor's argument that the standard that you cited has been subject to that the Spalding statute has been subject to more recent case law that refers to whether the ruling is outside of the principal outcomes?
Your Honor, I did have a brief opportunity to look at People versus Babcock, which was an issue regarding going above the sentencing guidelines. However, I have not had an opportunity to completely research that matter, and if that case law is incorrect, I do apologize. However, I do believe that even with looking at those cases stated by the people, that I don't believe the trial court came to a decision that is beyond the range of possible or principled outcomes. I think that that decision that Judge Wadel came to in hearing this matter in the district court was a reasonable decision based on all of the testimony that he considered in coming to his opinion.